This episode of the Etsy Conversations podcast is sponsored by Etsy Success Strategies, the audio series. Subscribe to these premium podcasts and listen your way to successfully selling on Etsy. If you struggle to keep up with the Etsy Success emails and other educational materials from Etsy, or if you've fallen behind in going through the seller handbook, then sit back, press play, and get caught up one recording at a time. Subscribe now at convome.com/read to me, and you'll get immediate access to the entire library of audio recordings not available on the free convome.com site or anywhere else. Then stick around because I add new audio content to the library continuously. If you like what you hear in this episode and want to hear more, go to convome.com/read to me to subscribe to Etsy Success Strategies, the audio series.
Welcome to the Etsy Conversations podcast, featuring inspiring interviews with Etsy shop owners, hosted by Ijama Elazu.
Thank you for joining me for another episode of the Etsy Conversations podcast. I'm your host, Ijama, and this is part 2 of your copyright questions answered. I have with me again my guest, Jared Haney. He is a lawyer with Cambridge Law Firm in Colorado. Jared, thank you so much for coming back and welcome again.
Thank you, Ijama. It's great to be with you again, and had a great experience with the first podcast. I'm looking forward to this one.
Thank you so much. So if you listened to last week, or if you didn't listen to last week's episode, go back and listen to it. We covered a lot of ground, particularly things that had to do with copyright, and Jared defined some terms that we hear a lot in the Etsy community, the difference between copyrights and trademarks and intellectual property, etc., and licensed products. So that's a good one to listen to. And so this week we're going to pick up from where we left off in the last episode. And Jared, are you ready for us to just jump right back in?
I am. Let's do it. This sounds great.
All right, good. Thanks. So the first question is from an anonymous seller, and it says, is it true that Etsy can remove your listing for even having something trademarked in your tags? And I'll explain this one to you, Jared, because I know you're not really familiar with the Etsy ecosystem. And actually, this might be even too specific, but let me give you some background. So in order to get found when someone is looking for something on Etsy, Etsy allows you to put certain tags or phrases, which they refer to as tags, so that if someone is searching for blue headbands and you sell blue headbands, you can use that as a search term so that when someone searches for that, your product shows up in Etsy search. And so what this person is asking is it okay, or not is it okay, but is it true that Etsy can remove your listing for even having a trademarked term in your tag? So using a trademarked term as a search term. Now, I don't know whether or not you'll know whether it's true that Etsy can do that, but if I were to rephrase the question in a more general term, I would say, can you use trademark terms to make yourself show up in searches?
Good. So, and I appreciate that distinction you made there as between what basically the law says and what Etsy is or can be doing. So I would say the first question is relatively easy to answer, and that is courts in this digital age have addressed that issue, that very issue about using trademarked terms to help direct searches your way, even though no one sees it. It's all behind the scenes. And the answer unequivocally is those terms are protected even though you're using them behind the scenes. They retain those protections. Now, the same principles apply though to those terms that are hidden in those tag searches or whatever you want to call them, so that if you were entitled to use them, for instance, on the last podcast that we did last week, we talked about we talked about the Volkswagen mechanic and the situation he had where Volkswagen sued this shop owner, this auto mechanic, because he was advertising on his website that he could repair, among other things, Volkswagen vehicles. The court said, no, you can go ahead and do that. There's no likelihood of confusion, and the only way to tell people that you repair Volkswagen cars is to tell them that you repair Volkswagen cars. So he was able, even though Volkswagen was a trademarked term and subject to protection, the court said, no, this mechanic can use that term on his website to let people know what he does. So if this mechanic, for example, were placing a tagline saying Volkswagen repair on his website, and he would be able to use that the same way he could use it in the open. But what you can't do is direct traffic to your website that would otherwise go somewhere else if you have no right to direct them there using those search terms. So I think the question included, for instance, the word Disney. If you don't have a license to sell Disney characters or Disney type products, then there's no reason that it's not like you're the mechanic. Disney characters don't need to be repaired. So, if the only reason you're doing that is to direct traffic to your site that would otherwise be going to Disney or to a licensed dealer of Disney products, then that's probably going to get struck down and be held to be an illegal use of that trademark. Same thing with Disney characters. And we talked about Simba the lion last week. Yeah. If Simba is one of your terms, that's probably going to get you in trouble because Simba is his name, is the Disney character's name, unless your name is Simba and you're doing something else, right?
Yeah.
So that's a tough sell. Now, whether Etsy can actually remove the listing, that gets into a whole different realm. We talked last week about whether Etsy was even trying to do those things in terms of policing products and other things that might or might not be violating some of these copyright or trademark rights. But I would say the issue that comes up there is freedom of speech under the First Amendment and whether someone has a right to do these things. And so there's competing interests, and Etsy may or may not have the right to do that. But whether they do or don't is really up to Etsy. The only recourse you would have would be to sue Etsy for violating your rights. Although there may even be, as I'm sitting here thinking about that, there may be an issue. The First Amendment only applies against the government generally. So Etsy, I don't know. There may be some issues. There may be some violation of your rights if they're taking it down. Maybe not constitutional rights, but there may be other rights of yours that Etsy is violating by interfering there. If they do so wrongly, right. If they take it down and you never had a right to it in the first place, then maybe it's no harm, no foul. But whether Etsy can or can't, unless you're interested in suing Etsy, there's not probably a lot you can do about that. So if it's done and there was an issue, it's, as a practical matter, unless you feel very strongly that you're in the right and you have some pretty good reasons, it's probably best just to move along.
Okay. So just to make sure I understand this. So if you have the right to use a trademarked term, let's just take Disney. So let's say you are licensed to sell something that you make that incorporates something that's trademarked or copyrighted or licensed to Disney. Well, you have a license to sell it. You can use Disney in your tags if you have if you have permission from them too. If you don't, you really shouldn't. You're not allowed to. Now, whether or not Etsy will do anything about it, they might choose to, or they might not. Is that the summary?
That is the summary. And Disney might choose to pursue legal action against you or might not.
Okay.
But just because Etsy doesn't act and just because Disney doesn't act doesn't mean
it's okay.
It's okay. Exactly.
Right. Okay. And again, this is referring to the tags. And I'm saying this for someone who's listening and wondering if just trying to get some clarity on this. This is referring to your tags. So we're not talking about using any Disney character names in your titles or your descriptions where they're seen by the public. This is in your tags where it's not seen. So one of the things that Jared said is even things on the back end that the public doesn't see, that's not outside facing, is also protected or are also protected by trademark and copyright laws. That's what you said, right?
That's right.
Okay.
And that gets into the weeds in terms of how things are being marketed and all these things. Are you driving profits away from licensed distributors of Disney products because making those things and so on and so forth. So there's a lot of thorny issues that come up, but the basic idea is you need permission to use those kinds of tags if that's what you're going to be selling and aiming for.
Wow. Okay. Now, let's say, so that would apply to someone who's making something. Now, how about because on Etsy, vintage sellers also have the freedom to sell their vintage items as well as supplies. So if, say, someone is listening and they sell crafting supplies or vintage items and the product that they're selling let me think of an example. Okay, so let's say they're selling a book on, actually I have a great example. So I have this book that it's a book of transfers, and it's characters from the Berenstain Bears. Do you know who those are?
Berenstain Bears? Oh, yeah.
Yeah, okay.
Papa Bear, Mama Bear.
Yes, brother and sister. Yeah.
Yes.
So the book it's a supply. It's a crafting supply, but it's a book of transfers, and basically you iron these onto like T-shirts so that you can have, the characters on your T-shirt. So it's not something that I made or anything, but the characters are what they are. Now, is it okay to use the name of the product and the company that makes it, because that's what people recognize. People recognize the Berenstain Bears. Is it okay in that situation for someone who's selling something like that to use those trademarked names in the titles, the tags, the descriptions, or not? Because there's no other way to say what it is other than saying what it is.
Now, help me understand. I didn't understand very well what the product is here. I understand the Berenstain Bears, but what's being used to as the product?
It's a book of, let me pick another crafting supply because transfers are hard to explain. So let's say it's, what now? Why can't I think of anything? Let's say it's, what's a crafting supply? Okay, a sewing pattern. Do you know what a sewing pattern is?
Yes. So to make a
like
dress,
a Cinderella dress,
okay.
and it says pattern to make Cinderella dress. Cinderella is copyrighted by Disney. We know Cinderella is a Disney character, but that's what it is. And it's a supply. It's not something I made. So it's not my own product. It's a manufactured product, but I want to sell it. Is it okay for me to use those descriptors that include trademark and copyrighted names because that's the only way to describe what it is?
Well, this is a good question, and you're starting to get a little more into the gray area, but I think at this point it's still the problem here is that what you're marketing in this example is your marketing a dress for little girls, and you could just market a princess dress or something, and certainly if you marketed it as a princess dress, you would be, at least as far as the marketing materials, you'd be fine as you're calling it a princess dress. The issue is if you want to call it a Cinderella dress that is by Disney and it has that classic Cinderella. I know I have little kids, so I've seen all these recently and a lot. Yeah. So the Cinderella's got that kind of that classic bluish, silverish look to it. Yeah. And so if that's the dress that you're selling is that classic look that Cinderella has, you're really taking that from Disney. And last week, you may remember I talked about kind of a rule of thumb to ask yourself why you're marketing something the way you are, and why the trademark issue is coming up. If the reason you're marketing something the way you are is because it's famous and you want to kind of hitch your wagon to that well-known recognition, that, as I said last week, that's kind of a red flag, because you could market dresses that were princess dresses that weren't in that classic color, shape, and all the rest, and call them something other than Cinderella dresses. So I would say you're still on thin ice under this example to call it a Cinderella dress, because it's kind of the chicken and the egg here is, I understand what your question is that it is what it is. It's a Cinderella dress, but do you have to be marketing a Cinderella dress? In other words, could you just call it a princess dress and sell it for what it is? So I think that would require probably some more analysis to see which side of the line that falls in terms of where you go from there. But just because you're marketing something that it's like you could sell a pirate costume. There's nothing wrong with that. But if you have the same font and the same letters and the same character and the same costume as the Pirates of the Caribbean, and you call it the Pirates of the Caribbean costume, then you're getting into copyright and trademark issues that you wouldn't get into if all you were selling was a pirate costume, which of course everyone is free to sell a pirate costume. But we touched on this last week. Remember, the copyright protection extends to the expression of an idea and not to the idea itself. So, for instance, Beauty and the Beast, I imagine Cinderella as well. A lot of these Disney tales are old fairy tales that Disney doesn't have a monopoly on the story of Beauty and the Beast. That's an old fairy tale that anyone could market and put out. But if you're going to sell Beauty and the Beast dresses with the characteristic colors that the Beast wears in the cartoon, and the bright yellow dress that Belle wears, and call her Belle, now you're saying, well, what you're really doing is you're piggybacking on Disney and the success that Disney had in their cartoon that they made.
Yeah.
And so when you start going down that path again with the Cinderella dress, if it's all the same and it has the same look that Cinderella has and you call it Cinderella, it's you got to start thinking pretty hard about those, because in my view that starts to slip over the line into what's prohibited.
Okay, so that's if I made the dress, right?
Yeah. So if you make dresses and you make them look exactly like the cartoon Cinderella looks, the Disney cartoon,
Yeah.
and you call them Cinderella dresses, even if you don't have a little logo with Cinderella on it or a little image of Cinderella on the blouse or something, you're still going to be in trouble, because you're using the Disney characters to promote your business in a way that you're not authorized to do.
Okay, but what about in the situation where, so Etsy allows you to sell vintage items, and vintage is considered anything over 20 years old.
Okay.
So what if I find a vintage Cinderella dress with the Disney tag at a thrift store and I want to resell it on Etsy? It was made by Disney. It was bought at a Disney store. It has all the Disney markings on it, and it says it's a Cinderella dress.
Yeah.
Can I sell that? Can I resell that rather on Etsy and refer to it as a Disney Cinderella dress? I didn't make it. Disney made it.
Yes, you can.
Okay.
So that's the there's a rule that allows you to do that with just about anything. And we're talking here about the Cinderella dress, but imagine you picked up a copy of Les Mis, which is copyrighted by, whoever published the book. You can resell it, right, without any trouble. No one's going to accuse you of copyright infringement for reselling it.
Yeah.
And but the issue is you can't alter it.
Right.
It has to be sold as is. So if you found this Cinderella dress, there's no question you can turn around and sell it for what it is and what it was purchased for originally. And I don't know, it sounds like Etsy has a rule, but there's no rule in the law that says you have to wait 20 years to turn around and sell something. Etsy can make its own rules on its own site. But you can turn around and sell a lot of copyrighted things that you purchased, a beautiful masterpiece of a painting, of a landscape or something that's copyrighted, but you can turn around and sell it. There's nothing that says you can't. So all of these things are open to do that, but you can't create your own products that mimic these things and try to take advantage of other people's success in ways that are illegal. Now, like we talked about, you could write your own Beauty of the Beast fairy tale and have your own creativity that went into it. You think of all the creativity that went into that Disney film, the original one that they did 25 years ago, and they've got Mrs. Potts and they've got the clock and they've got all these people. Yeah. All those things are now protected, and Disney created those things that were successful. But you could make your own fairy tale called Beauty and the Beast and do it your own way and market it in your own way. It could be a little animated film. There's nothing that says you couldn't. Disney may try and fight you because they might, I don't know, they may be a little bit defensive about that. But I think if it was original and if your creativity was different from Disney's, there's nothing to say that you couldn't do that.
Okay. All right. I think that's clear now. The next one is, it's not actually a question. This is just helpful input from another anonymous seller. And so, I don't think you have anything to answer here, but I'll just read it. It's just information for anyone who is listening.
Okay.
So it says, Etsy itself does not go through and remove items they feel are infringing. This is why you can search the word Disney in Etsy and get almost 1 million results. The copyright owner has to contact Etsy themselves to report infringement. Some people may say to themselves, well, Disney is huge and has more important things to do than shut down little old me. But this is not the case. Most big name companies actually employ people whose sole job description is intellectual property enforcement. So it very well may be that they just haven't gotten to you yet. Also, other concerned individuals who are not representatives cannot get a listing removed because of infringement. Only the intellectual property owner or the owner's authorized agent can. So if you thought it was your competitors who reported your listings to Etsy, this is not always the case. So this is someone who wrote in and about their own experience and was just explaining how some of this works. And there's an article on Etsy too that talks about intellectual property infringement. I'm going to link to that in the show notes for this episode, and I think that's where they go into that in more detail about intellectual property and I guess how they govern that on the website. All right, so I'll move on to the next question. The next question is from Teresa A, and it says, it kills me when people are selling Disney or professional college sports teams products on Etsy. It seems like this is infringement, but there are so many people doing it that maybe it is not an issue. Actually, we've just talked ad nauseum about that, and I think we know it's an issue.
Yeah, it absolutely is an issue. You need to get permission or you shouldn't do it.
Yeah. So that one, that's clear cut. Okay. The next question is from Mary M. of Recycled Album Art. And so Mary gave a little bit of background just to explain her question. She and her husband started a micro business just to clear out her husband's album collection. And he does woodworking and she has a gift for turning trash into treasures. And so they started making recycled album art coasters with warped record bowls. And so initially, she says, when they first started, they didn't include the artist and band name in the titles of their listings. But then people who found their items and wanted to find more let them know that it was hard to find what they were looking for because they weren't using the names of the artists that they were selling. And so they started adding the names of the artists and the bands to the listing titles. And then more recently, to optimize for SEO, search engine optimization, they started adding the artist and band names in the tags. And so over the last few years, they've added 2 statements to every listing that they sell. The first statement says, at Recycled Album Art, we repurpose and recycle only used record albums that we own. And then the second statement says, we do not reproduce any artwork, never have and never will. So Mary's question is, let me go back. So she says a bit more. I'm going to read what she says. In the 9 years of selling, we have received 2 complaints by representatives of 2 separate artists/bands pertaining to copyright infringement, and the complaints were resolved by removing the listing and the items from their inventory. In the same 9 years, their items have been presented in a book of recycled items in a local magazine and on numerous blogs. So that's really good. I cannot even begin to remember the number of sets purchased by family members of specific artists' band members. I've monitored other shops that really liked our idea and at times the actual wording used in the listings. However, it was very clear that they were photocopying the album cover image. And most of those shops aren't doing what they're doing now anymore. So her question is, Do we have a trademark or copyright infringement issue? And if so, how would we resolve the problem? They're trying to preserve the memories that people have of music.
So this is fascinating. I thought it was fascinating to read about.
I did too.
Wasn't that creative, I thought?
Yeah.
So she does. I'm glad that she recognizes that there may be copyright and trademark issues. So let's talk a little bit about those. The thing that this husband and wife have going for them in their little business here is that what they're doing is highly transformative. So
Ooh, that sounds like good news.
that's very good news for them. Now,
Good.
I don't want to, last week I gave a kind of a lengthy disclaimer, but the short version is I can't tell you definitive answers here, even if
yes.
most lawyers can't tell you definitive answers ever. But there is in the copyright world, there is something called fair use, and we got into that a little bit last time. And I was careful to try to help your listeners understand that fair use is probably more limited than what it sounds like. It's not as broad as a lot of people would like it to sound or to be, but it does have some teeth, and particularly where the use is what the courts call transformative. In other words, if you're using copyrighted material, in this case, the artwork that appears on these record labels and these record covers is original, it's copyright protected, as we've talked about last time. I won't get into all of that, but it is copyright protected. Okay. And the question then is, are you able to take these old album covers that have essentially no other use but to be tossed in the trash and turn them into something? She said the records were so scratched they weren't even good anymore, but they have these albums. Well, of course, you could use them for something. We know from what we just discussed, you could certainly turn around and sell them, just like you could sell that old vintage Cinderella dress that you picked at the Goodwill or something. You could turn around and sell them in their current condition. Now the question is, can you turn around and make a new product with them? Normally the answer would be no. Because at least if there's some use to them left. I would argue that in this case, there's no useful life left except for the kind of thing that they're doing with them, which is either to frame them and put it on the wall, or to create some other creative use where you're using the artwork, but in some other creative way. Certainly, they're not going to be used to house the original records anymore because the records are no good. So in this situation, it's a gray area. I did a little research on this before we got on the air, and I couldn't find any cases where the products were useless and they were turned into a repurposed use that was totally different from the original use. And but for that repurposing, the products were basically useless. I couldn't find anything that was directly on point. So what I'm saying is that there's certainly some good arguments in favor of protecting this kind of activity, both legal and policy arguments. You don't want to just throw things away if you don't have to. Yeah. But on the other hand, I'm also saying that it's not clear how a court would rule on it. She's been contacted by a couple of artists that sound like they felt like at least this was a violation of their copyright protected property. And also she's using tags, it sounds like, which we've also talked about. So all of that is, it creates a very interesting situation from a legal perspective. I would say they're doing pretty good by taking things a step at a time. It's probably not worth their dime to fight these things, but they may have a decent case if they did have to fight it. But I think the direction they're taking is very practical. If they get contacted, it sounds like they're just removing those. And that's a practical approach. A lot of times it's unclear who would win the lawsuit, in which case, the people with the deep pockets usually win, because people with the shallow pockets, with the empty pockets, they just kind of
give up. Yeah.
So I don't know. I think it's a fascinating question. I think it's certainly the thing they have going for them is how transformative this use is. Yeah. It's not cutting into their profits. That's another factor the court will look at. These performers, these artists, the fact that this husband and wife are selling little posters or whatever is not cutting into anyone's music sales. Right? So I think they have a pretty good argument that this is the kind of thing that is very transformative. It's not cutting in, it's not hurting anyone. And it's not disparaging them. Sometimes a court would even say, well, what you're doing is disparaging. Usually that comes in with unsavory uses of copyrighted material. This is very
flattering.
Practical. Yeah, and it's nice. So I think they'd have a pretty good chance, based on what I'm seeing here, of succeeding in a defense if they had to. And in the meantime, it's very practical for them to just take it down if they need to, if they get complaints. I thought it was a very creative use there, and that's the kind of thing we've been talking a lot on the show, this show and the last week's show, about uses that maybe are not very creative. For instance, some of the people have complained, I see Disney characters being used all over on different products, and that's not very creative. It's just using it. And so in this case, it's a creative use of something that otherwise would probably be tossed. I like it, but I can't give a definitive answer one way or the other, but I think they're doing pretty well by the course of action they're taking.
Okay, well, thank you. Yeah, I thought that was interesting. I wanted to hear what you had to say too, because I thought, wow, I've never seen that before, and I have no idea because it's just so different. So, Mary, there you go. All right. So the next question is from Marlene P, and she runs the Etsy shop Lightbeam Fairy Tales. And her question says, is there a place, preferably on the internet, where we can check if a name, sentence, or product is trademarked or copyright protected, and in terms we can understand? I remember once landing at one site that made it so difficult to understand that only lawyers could read it.
Well, I share your pain, Marlene, and first of all, we'll start with the easy one. The copyright protected, we talked about this on last week's episode, but almost everything you see on the internet, whether it's in print or a photograph or music or whatever it is copyright protected. You can just assume that. And so unless you have permission, or unless sometimes you'll see, we didn't address this, Ijama, but sometimes you'll see people that actually go out of their way on a website to say, you may use this photo, or you may use this whatever it is, poem or something, for either commercial or non-commercial use. It's free for the taking. Yeah. And so if you get that, then you still have the issue of hopefully that's the person with the copyright that's telling you that, and they're not
Oh,
just someone else's copyright.
could be that too. Yeah.
But you're in pretty good shape to use something that someone gives an explicit authorization to do that. So that is a big exception, of course. But if you don't see some kind of authorization to that effect, then the rule is you can't use it except for the limited purposes we've talked about, fair use, limited use, things like that. But just to take it and use it. So I would say it's not worth your time to try to find a website that chronicles the copyright protections, because as a practical matter, everything you see is copyrighted, and unless you are planning to litigate the issue, there's really no need for you to go down the path of trying to figure out what is and isn't copyrighted. As far as trademarks go, if you're trying to think of names for your products or other things, or names for even for your business, and you want to know what has and what has not been trademarked, that's a different story. Unfortunately, the only places that keep these things are government registries. Sometimes companies will keep a list of their own trademarks, and you can search those out, and some companies will publish those. But otherwise, if you're just looking generically, the U.S. Patent and Trademark Office keeps all registered trademarks at a federal level. Some states have their own trademark systems and keep those as well. I agree with Marlene that it's not always the easiest thing to decipher, but
Yeah.
if she's really interested, or if some of your other listeners are also really interested in knowing whether a particular trademark has been already claimed, I think that's when, if you can't figure it out with a quick search, you probably ought to reach out to a lawyer, and they can help you figure that out.
Okay. So the U.S. Patent and Trademark Office, the website is uspto.gov, I believe. I'll link to that. I'll dig it up just to make sure. Oh, you said right?
Yes, that is right.
Oh, okay. So I'll put the link in the show notes for this episode, but I have a follow-up question to that. Marlene is in Portugal. So will that apply to her, or is there a place that has trademark websites for other countries other than the U.S.?
So I don't deal with international trademarks,
Okay.
or the defense of those. There are treaties in place between countries that and international law that is in place to allow the enforcement of trademarks across international borders. And in essence, you can basically, what that means in a nutshell for lay people is that things that are trademarked in the United States are also trademarked overseas. So you can't move to Africa or Asia or Europe or Australia and start copying Disney characters because you're not on U.S. soil. So that's the short answer. Portugal, I don't know anything about the laws of Portugal and how a trademark would be obtained in Portugal domestically. But if the concern is how and what use can be made, the short answer is these things are protected here and abroad and under international law and under treaties. And it's a big problem. You've heard, I'm sure, most people have heard of pirated copies of movies and other things that come out.
Oh, yeah.
Sometimes even before the original is released in the United States. And it's a big issue, and it's absolutely illegal. So that's the short version on that. That's about all I know on international trademarks.
Okay.
And copyrights.
Okay. Oh, two things you just reminded me of. One, I'm going to say, I probably shouldn't say this, but it doesn't matter if I do. There's no way they're going to catch them. But I grew up in Nigeria, and we used to get pirated movies all the time. That was the only way we could watch movies. And we didn't know they were pirated. It was after I came to the US, I realized that's what they were. Because, I saw movies and I was like, wait, why is that? Why is there someone moving, or why is someone laughing? This isn't a comedy, because people would record them in movie theaters and then sell them, or they would get like early release copies and then make copies. And anyway, but it's really hard to police over there. So I don't know if anyone will ever get held responsible for any of that. That was
it's a big issue for those people, and a lot of people make money on it.
Oh yeah,
doing that. But yeah, it's not morally right, of course, but it's also illegal.
Yeah, that was the first thing. The second thing was, Marlene, this is more for you. I know that I've come across somewhere on Etsy there was a link I saw that linked to a list of all the all the trademark offices. Well, I don't know if it's all, but it was, a long list of links to trademark websites for each country around the world. And I don't think it covers absolutely every country, but at least all the countries that have people who sell on Etsy on them. It's in one of the Etsy articles. I will dig it up and I will link to it in the show notes for this episode, so you can look up the one for Portugal. It might be the one you saw that was too hard to understand for a lay person, but in case it wasn't, I will link to that for you. Okay, the next question is from Judette, and she runs the Etsy shop Soap Freaking Good. I like the name of her shop. Soap Freaking Good. That's SOAP. And Judette asks, I recently launched a soap shop on Etsy, Soap Freaking Good, and I'd like to add superhero-inspired soaps to my shop. I haven't done so because I'm afraid to break copyright laws. I'd like to know if it is legal to create items that feature images of well-known characters. I think you have answered this question already.
Yeah, we haven't. I can't remember if it was this week or last week that we talked about that, but we did talk about it, and without permission, it would be illegal to just borrow those characters and put them on either the marketing or on the product itself or anything like that, or even as we talked about, in tag names or taglines on your website.
Okay, so I have an addition to Judette's question. She actually has two, but for this first one, I thought of something too. Does it make a difference if the item is perishable, like soap? So it's not like it's a t-shirt or a scarf or anything. It's soap. It's going to be gone after it's used. Do the same laws still apply?
Yeah, it's a good question. The same laws would still apply because the test really, the legal test is whether there's any likelihood of confusion and whether there's any likelihood that the consumers will think that this is affiliated with, for instance, Disney. Let's say you had Little Mermaid soap or something like that. It would, the question would then be, well, who is this coming from? Has Disney authorized this? And it's likely to be a confusing thing to consumers as to who is allowing this to happen. So it doesn't matter whether it's a shirt or soap. Now, soap is granted, more creative in terms of the use of those things than a t-shirt might be, or bed sheets or something that you might see for little kids or something, because you see those things. But even the soap, or even if you put it on race cars or something that maybe you wouldn't think of it's still all the same principle, which is you really, if you're just piggybacking on their trademark or their copyright, you're really putting yourself at a position where it's probably going to be an infringement issue.
Okay. All right. Well, that's that then. I thought, oh, well, if it's soap or it's food like, Mickey Mouse cookies, or I don't know why I'm picking on Disney so much. There has to be someone else I can pick on. But I thought, well, it's going to disappear. So what's, is it really a problem? I mean, you could just eat the evidence or wash the evidence away, but I guess not. Okay. So Judette's second question is, I'd like to know if it is legal to create a product with colors inspired by well-known characters and use the character name in the product description and/or product title.
Okay. For this one, I mean, it's getting a little farther away from just flat out using the characters, right? And now you're just maybe color patterns. Again, I would say here, clearly you can make soap of any color you want. No one's going to stop you from making, I don't know what, to pick on Beauty and the Beast. If you had like, the purple that the Beast wears at the dance, and then you got the bright yellow that Belle is wearing. You could put those in your soap or in your marketing, those colors. There's nothing wrong. The issue then becomes, though, or almost certain, I think, if all you have is colors with no tagline saying this is Beauty and the Beast soap, then no one would really know or think to associate yellow soap or gold and purple soap with Beauty and the Beast. No one would think of that, right? So I'm almost thinking here that you're certainly entitled to put any color combination on your soap that you want. Now, I'm talking here about Disney characters. There could be actually a problem if the color combination that you copy is bright orange and it looks just like Tide, right? And your soap is called, I don't know,
Glide.
Wave something.
Wave, yeah.
Yeah, so you're and basically you're copying Tide, but you are doing it in a way that's kind of sneaky. You get people thinking, oh, it's bright orange, it's Tide, it must be awesome, must be the soap I want. So that can be a trademark infringement. There were cases that went up to the courts involving the little trim around the magazines, the little red trim that goes around Time magazine, the frame.
Yeah.
And the little gold trim that goes around National Geographic.
Oh, yeah.
Right? And so those are trademark protected. It's called trade dress. And so even though there is nothing wrong with any particular color combination of the soap, I also want to be clear that you can't, in the soap world, it's like in the magazine world, I can't go out and use a little red frame and create my own national news magazine, because Time is going to say, that's our realm. You go pick your own image. And so in the soap world, you can't copy other soap products. But if you're trying to go after a Disney theme, a purple and gold or whatever it is, I don't see any problem with that. The issue I see is that no one's going to know it's Disney unless you tell them, and that's where your problem's going to come in.
Oh, I see.
So you can't use the Disney taglines, as we've talked about, to market those things unless you have Disney's permission. And you can't call it Beauty and the Beast soap, copying Disney's Beauty and the Beast. Now, you could call it Beauty and the Beast soap. We've talked about this. Beauty and the Beast is an old fairy tale. Disney doesn't have exclusive rights to the tale. It just has exclusive rights to the way it portrayed that tale. And so, it has a character, Gaston, and it has all these little animated figures and everything. And so that is Disney's version of that story. And And if you're going to try to get in there with colors to mimic that, I think you're getting, especially if you're going to say it's Beauty and the Beast soap and it just happens to be gold and purple.
Mm-hmm.
Well, Disney is going to see, well, I see it's gold and purple because you're trying to copy our color scheme. Now, I don't know if Disney would care very much, but I mean, it's soap, and I've never seen Disney soap before, but you kind of see where I'm going. The more you're trying to piggyback and use their creation to market your products, the more dangerous it becomes. But you could market your own products with any colors you want. The hard part's going to be trying to associate that with, in the minds of your customers, that this is a Disney theme.
Okay, so I have a question. So let me set up a scenario. So say Judette makes soap in the shape of a dress and makes it yellow and calls it Beauty and the Beast yellow soap.
Uh-huh.
And then has another one that she makes in the shape of a daffodil. And it's yellow as well. And she calls it Beauty and the Beast yellow daffodil soap. The other one is Beauty and the Beast yellow dress soap. Beauty and the Beast itself is not exclusive to Disney. So she can't call it, let's say she called it Belle dress soap or Belle yellow dress soap or Belle yellow daffodil soap. Those would be infringements, but Beauty and the Beast yellow or Beauty and the Beast yellow dress soap and Beauty and the Beast yellow daffodil would be okay.
Those are pretty good analogies there, good examples. I would say the daffodil, my recollection in the movie, the daffodil has nothing to do with the movie, right?
No, nothing to do with the movie.
In that case, you can just call it Beauty and the Beast. Now, the other thing that comes into play is if you're going to call something by the fairy tale name Beauty and the Beast, you can't use the font and the colors that Disney used to market their movie.
Okay.
Right? So you can't, there's a certain way, and maybe you can picture in your mind if you've seen the film, how Disney marketed the movie. Beauty and the Beast was put in certain font and colors, everything, right?
Yes.
And so if she were to market this as Beauty and the Beast soap, she should have a very distinct Beauty and the Beast font and colors. You're starting to get risky when you copy the colors, because now you're saying, well, it's partly like it. I'm trying to get there, but I want to stay away. You're kind of like those magnets. How close can you get them before they jump together?
Yeah.
And so I would say the daffodil idea, or something totally unrelated to the film. Maybe it's Beauty and the Beast, and it's just a picture of a castle, but it's not the castle that looks like anything like Disney's castle in the film. It's just a castle of some sort. Well, that's okay. You like we talked about, Disney doesn't hold an exclusive license to the fairy tale. They just have rights in how they portrayed that fairy tale. So I would say the example you used about the yellow dress and Belle's yellow dress, that's probably, Disney would have a good argument to say, now hold on, we created this yellow dress and it happened to be in this movie called Beauty and the Beast, and you're calling your thing Beauty and the Beast, and you're using the same name of the character to market your soap. So I would say that's probably over the line to sell soap that looks in the shape of Belle's yellow dress and call it Belle's yellow soap.
Okay.
But if you use something unrelated, like a daffodil or some other thing, or even if you have a dress, see, even the dress thing, though, I don't know. You'd have to go back and see what the old fairy tale said was, is there even such thing as Belle in a dress in the old fairy tale, or is that just all in our minds because we've all seen the Disney film?
Oh, yeah.
So those would be the kinds of things Disney would argue if it came to it. They would say, no, hold on. If you go back and look at if you go back and look at the fairy tale, there's no dancing. That was something we made in our version of the tale.
Yeah.
And so then they would say, see, we got you. You're just trying to copy us. So there's a lot that goes into it. But if you wanted to market these things, and if you wanted to make your own fairy tale line, you could come up with a bunch of, maybe you have an ugly duckling soap in the shape of a duck, and maybe you have you go through all these different fairy tales from old time fairy tales.
Yeah.
And you could do that, but you shouldn't do it in a way that copies the way that Disney did it.
Or anyone else.
Or, yes, we're talking about Disney, but
yeah.
Or anything else. That's right.
Yeah.
It's got to be your own telling of the story. And if you want to have, Prince Charming, that's Prince Charming is certainly a fairy tale idea. And you could have Prince Charming soap, but he shouldn't have the same costume that he had in Disney's version of Snow White or whatever, right? So I would say once you start trying to copy things, even if it's just colors or dresses or whatever, you're really getting onto thin ice, and you ought to think about, well, what am I really trying to do here? It sounds like if what I'm trying to do is just piggyback on Disney, it's probably not going to be a good place to go.
Okay. Okay. I have one more question, but I'm going to squeeze one of my own in here, because this one is also kind of along the lines of what we're talking about, but not. So the question I want to squeeze in has to do with, it's going back to phrases and words and whether or not it's okay. So what about a situation where you want to, and for this, I'm thinking about like for people who sell quotes and artwork. Mm-hmm. So some quotes, I know, there are lots of sellers, who have quotes, and then you can give attribution to the quote, and that you're not saying it's yours, you're attributing it to whomever said it.
Right.
Is it okay if you quote someone and give attribution? Is that still, but you're making a product out of it and selling? Is that okay, or is that not okay? This is one of those things that as non-lawyers, your audience probably thinks, oh, there's an easy answer to this, but surprisingly, there's not an easy answer. There's certainly nothing in the law that says that's automatically okay. Mm-hmm. And in fact, this has become a bigger issue, somewhat related issue with in the teaching context, because for years people thought, well, I'll just put, since I'm a teacher at a university, I can just post on my website, I can copy anything I want and have my students read it because it's all educational. Mm-hmm. Recently, there's been a little bit of a pushback against that, and people whose books are being used or quoted materials, articles, are saying, no, just a minute, this is a copyrighted thing. Just because you're having students read it doesn't mean necessarily that they can do that. So I know that's not exactly your question, but the point is, when you're using a quote, to go back and look at what fair use is, mm-hmm. Might depend on, what context the quote was from. Was it from a president of the United States? You're probably going to be okay, right? Because the president's not going to come and sue you as a practical matter. Well,
never know, right?
You never know.
But if it's from, an author, and you've quoted something out of a book that is, obviously copyrighted, and you're making a profit on it, it becomes a little bit more, is it transformative? Probably not really transformative, because the author wrote it in the book for the same reason that you're giving it on the plaque, which is it's a good idea. The author liked the idea, and you're just repeating it.
Yeah.
So not highly transformative. It's a little transformative. One was in a book that you had to pick up and read 500 pages. You just put the best part of the book in 2 seconds. I can read it. So that's, I would say, the lawyer in me wants to hedge and say you're probably on, you ought to analyze each one. But I think as a practical matter, giving credit where credit is due, and putting inspirational quotes on some kind of artwork or some other like a coffee mug or something like that. If you're giving credit to where credit is due, as a practical matter, you're probably going to be all right. But the lawyer in me is also saying, well, there's nothing in the law that says that's automatically okay. And so you'd have to look at what was taken, how much was taken. Is the quote you're pulling, is it from a poem, and the poem's only 5 stanzas long and you're quoting the whole poem? Well, maybe not. Maybe you need to get permission then in that case, right? Because you're copying the whole thing.
Right.
Are you quoting one phrase out of Les Mis, 1,500 pages long? Well, maybe that's all right. It certainly is more all right to do in the context of education, because fair use allows that for education.
Okay.
When you're putting it on artwork or mugs or other things and you're selling it for a profit, you're clearly using someone else's idea to make money. So it kind of goes both ways. As a practical matter, I'm not sure that it's probably a huge concern in most cases when you're giving attribution to that quote. There's certainly no law that allows that to be used as a blanket permission.
Okay.
So you got to think about it. If you're really going to do that and put it out there, it might be worth talking to a lawyer and say, hey, here's the quote. What do you think? And then you can analyze the fair use factors, which is most likely where that would fall in, as to whether it would be okay or not.
Okay. So when you say all that, what comes to mind to me is just thinking practically about things that I've seen and even myself have sold on Etsy. Like popular, like if someone on a reality show says something in the course of a conversation that just happens to take off or resonates with the audience, and then making something from that. So, putting it on a mug or on a t-shirt for the period of time it's, in front of people, or it's popular, and then, selling that. So even something like that, does that seem sketchy?
I don't know if I would call it sketchy. I mean, we all like to see pithy quotes or inspirational ideas or something that makes your mind start turning. Those are things that everyone likes to see. It becomes an issue when, for instance, if you there's an old country song that says, it's not what you take when you leave this world behind you, it's what you leave behind you when you go, something like that. That's a great little pithy quote, but and it's certainly not, the idea is not unique. Everyone has thought or said that at one point in their life. But how he expressed it was his expression. It's a country song, so you could quote it and say, and give the author of the song credit and put it on a, and I've seen that's the one that came to mind, because I've seen that put on different artists' little country type knickknacks that you can hang in your house or something. And I think that issue right there is a good question as to whether or not. My sense is that's probably, as a technical matter, is probably again, it's the lawyer in me talking, but I think it's probably prohibited under the law, because this fellow wrote the lyrics, and his expression of the idea is protected. The idea itself is not protected, but the way he said it is protected because he wrote it down. I know that goes against the grain of what you see. Again, this kind of goes back to some of the stuff we talked about last week more, I think, where people say, well, I see this and I see that. You do see it a lot. And as a practical matter, everyone's going to respond differently. Maybe that country singer, he sees those things on the internet and he's flattered that people like his idea and they've got his name on it or whatever. Other people might say, wait just a minute, I'm going to sell those knickknacks and it's my prerogative to do that and not yours. So what's legal and what's, what actually happens are sometimes two different things. But the law says that the expression of an idea is protected, and there's the fair use factors come into play, and that would, I think, be your best defense if you were going to be in that kind of business, is what constitutes fair use. Certainly, you see this a lot in news reporting. You've probably even maybe heard about some of the buzz that's going around. Some bigger news outlets are upset that smaller news outlets put links on their site to say, hey, the AP is reporting this, or CNN is reporting that, or Fox News is reporting this. And they say, look, who says you can even say what we're reporting and give a little snippet? And so there's been a little bit of, and it's an unanswered question as to how much you can say on your website that is being reported by other people. Because in essence, you're taking their copyrighted material, because these guys they're in it for money too. They make their profits doing their thing. And if you're giving the 2-minute summary, it's kind of unclear as to where that line is drawn. So in a nutshell, if you're in that line of business and you intend to really make some money doing that, I don't think anyone cares if you put a quote up in your house and you make your own piece of art. I mean, as a technical matter, maybe that's different, but one of the fair use factors is whether you're making money at it.
Yeah.
And so if you're doing this commercially and you're trying to sell hundreds or thousands of these products, I would run that by an attorney and get a more in-depth analysis on the types of quotes you intend to run. Are they old quotes from the Bible? Are they new quotes from a pop star who's still alive today? There's a lot of things to consider, but I think the answer is not as easy as your listeners might have hoped it would be.
Yeah, as I hoped it would be too. Okay, so here's the last question. It's from Jessica, and she asks, is it still an issue if you use the term inspired by when describing an item? And then she explains that she created a product that was inspired by a character, and she wants to know if that's okay to do. She doesn't have this listed, so she's basically wants to find out before listing it if it's okay to say that.
So I would say the answer to Jessica's question is very similar to the thing we were just discussing a few minutes ago about the color scheme used in the soap, and the difficulty I flagged that I thought would be it's one thing to use a color scheme, and no one's going to stop you from using a color scheme that is attractive, but how are people going to know that the color scheme is associated with what you want them to associate it with? We keep talking about Disney, but if your thing is a Disney theme and you're selling soap, no one's going to think you have a Disney themed soap unless you tell them. So now this listener, Jessica, she's saying, well, what if I just tell them? And I think that's a problem, because just like using Disney characters in a tagline or something like that would be out of bounds. You can't tell people that, oh, this is inspired by Beauty and the Beast, and it's if Disney hasn't allowed you to do that, because again, you're just using Disney in that case to help sell your products, but Disney hasn't allowed you to do that. So unfortunately, you can't say what it's inspired by without probably getting into a little bit of a thin ice there. You could certainly do it. You could just create gold and purple soap and just let people come to their own conclusions, but using that color scheme by Disney puts you on thin ice. Again, I'm telling you the legal answer here. As a practical matter, does Disney care if you say it's inspired by? I don't know. But I think the legal answer is they would be within their rights to email you or send you a letter and tell you to stop.
Yeah. Well, okay. So Jared, I think this has been very informative in that I know you probably noticed a similar thread that ran through a lot of the questions. And I think this gives a good idea for a lot of sellers too, who have similar questions or, doing something similar. I know not everyone is dealing in the Disney realm, but many other products that people sell that now, in light of what you've said, it sounds like they might be crossing the line into infringing on someone else's copyright or trademark or intellectual property stuff. So this has been really educational. There were some things I thought were okay that you've now revealed are not okay. And I really appreciate you taking the time out to explain all this in great detail too. One of the things I know, which I think I mentioned to you once before, is that when it comes to these issues, one of the things I've noticed is that within the Etsy community, we try to help each other out. And sometimes because we're not lawyers or we're not accountants or we're not specialists in a particular area, it's like the blind leading the blind. And there's a good amount of misinformation, even though it's well-meaning, from people who mean well and are trying to help other sellers. And so I'm just so grateful that you took the time to respond to these questions and just give us a real professional opinion about them. Not everything was good news, but I think it's better that we're informed and know what the right thing to do is. And then now anyone who listens and can infer what applies to their own situation is armed with the knowledge to make the right decisions. So thank you so much.
Well, thank you, Ijama. I'm really pleased to have been on here and to field these questions. And I'm impressed with the just all of the way that the Etsy community does work and how organic it is, how the variety of the different business ideas. So yeah. I wish all of your listeners all the best, and I think they're all doing a good service by promoting the things they are, and hopefully we can help them with this little podcast to steer them a little, here or there if they need some of that. But if they do have questions, I'm happy to follow up with them, and we can get into some more detail if they have any specific questions.
Thank you. And now, if you do have any additional questions, as I mentioned in the first part, Jared is my lawyer. I consult with him when I have questions about legal issues and legal matters. And so the best way to get any additional questions that you still have after this conversation, this and last week's conversation, or if there's something we didn't touch on or we didn't go deep enough, is to leave a comment on the website under the post for this episode, or you can email me directly, interview@convome.com, and send me your questions. I will review them, and I'll wait till I have enough. And if there are things that we haven't yet discussed and things that I think should be passed on to Jared, I will. FYI, he is a practicing lawyer. He gets paid to do this. And so this isn't free. So if you do have any questions, I do want to help you as well. So post them on the website or email me directly, and then I will take them to Jared and I will cover the cost for that. So I don't know if I should put a time limit on this, because I don't know when you're listening to this, but if you do, email me or post them on the website. I read every single comment. I respond to every email myself. I will see it. It might take me a while to respond, but I will respond eventually. And again, I just want to thank you, Jared, for being on the podcast. And I thank you for listening to the podcast. I will be back next week.
Thank you for listening. You can subscribe to the podcast in iTunes, and while you're there, please leave a review too. Visit convome.com to leave a comment or feedback on this episode.